Good morning. Welcome and thank you for joining us here today. I'm grateful to be here, and I want to acknowledge that we are gathering on the traditional unceded territories of the Algonquin Anishinaabe people. My name is Pam Hrick, and I'm the Executive Director and General Counsel of the Women's Legal Education and Action Fund, also known as LEAF. LEAF is a national nonprofit that advocates for the equality of women, girls, trans and non-binary people. And we've been doing that through litigation, law reform, and public legal education since 1985. We know that sexual violence is an inherent attack on the equality rights of women, girls, and gender-diverse people. For decades, we have seen how the criminal legal system fails to adequately respond to sexual violence, let alone prevent it. We know that for many survivors, the criminal legal system not only fails them, but re-traumatizes and re-victimizes them over and over again. Yet, it often remains the default system that we tell survivors to turn to. That is why LEAF is here today to launch its Avenues to Justice project. This project calls for looking beyond the criminal legal system and expanding access to restorative justice and transformative justice for sexual violence. It builds on the expertise and leadership of communities that have long advocated for and delivered these forms of justice, including Black, Indigenous, queer, trans, and sex worker communities. As part of this project, LEAF commissioned 2 subject matter experts to help develop a report to provide the foundation of LEAF's advocacy to enhance access to restorative and transformative justice for sexual violence. I will now invite Dr. Mandi Gray, one of the report co-authors, to tell you more about this work.
Thank you, Pam. I'm Dr. Mandi Gray. I am an assistant professor at Trent University in the Department of Sociology, and I'm an expert in institutional responses to sexual violence. The extent of injustices that survivors experience following sexual violence is really what ultimately led me to wanting to embark on this important project with LEAF, in search of meaningful alternatives that would benefit not only survivors, but also people who had caused harm. The project methodology, analysis, and recommendations were guided by an advisory committee comprised of legal and restorative transformative justice experts from across Canada. In addition to a comprehensive literature review, we conducted 41 interviews with subject matter experts. Interview participants included grassroots facilitators, practitioners working within the legal system, lawyers, including criminal and civil private bar, as well as crowns. We also interviewed staff at community-based and campus sexual violence centers across Canada. The interview participants resided across the country and reflected the diversity of Canadians. The interviews informed the recommendations presented in the report. One of the recommendations is the need for improved education for all Canadians about restorative and transformative justice approaches to addressing sexual harm. Restorative justice is relevant for many forms of harm, but specific education developed in collaboration with gendered violence and restorative and transformative justice experts is needed to dispel myths that restorative justice is the easy way out for people who have caused harm. Another key element that we heard from practitioners across the country is that sexual violence can include a wide spectrum of harms, many of which would be more appropriate for restorative or transformative approaches as opposed to the criminal legal system. This could be beneficial to all parties involved, but it requires public knowledge about restorative approaches to harm. Specialized education is needed for legal system actors that's tailored to the unique needs of criminal lawyers and judges. There's also a need for training for restorative justice practitioners with expertise in restorative justice, but not the unique power and gender dynamics of gendered and sexual violence. I'm now going to invite Dr. Tamera Burnett, my co-author, to the podium to provide a summary of the other recommendations provided in the report.
Thank you, Dr. Gray. As stated, my name is Tamera Burnett, and I'm a non-practicing lawyer with a PhD specializing in sexual assault law. Like Dr. Gray, the frustrations and dissatisfaction of survivors with our legal system has inspired much of my work, and I believe it is crucial to ensure that those who experience violence have an array of options available to them as they search for redress. Increasing access to restorative and transformative justice is one such way of achieving this goal. As such, one of the primary recommendations from our report concerns the need to reevaluate and end the current moratoriums on the use of RJ and TJ processes for sexual assault. According to Section 717 of the Criminal Code, in some circumstances, alternative measures can be used to resolve criminal charges, and these can include restorative processes. However, there are currently either complete prohibitions or heavy restrictions on the use of alternative measures for cases involving sexual violence. So, for example, if you live in Ontario, Alberta, Quebec, or Newfoundland, they are completely off the table. These moratoriums were put in place many years ago because of concerns over whether restorative and transformative justice was appropriate for serious offenses. There was also worry over whether or not we could ensure the safety of survivors. However, these are not insurmountable challenges. We've had years of additional research and practice that can help us address these sorts of issues. Further, increasingly survivors themselves are expressing interest and desire in accessing RJ and TJ opportunities. Thus, it is time to end these moratoriums. The need for sustainable and long-term funding is also crucial to properly implement restorative and transformative justice opportunities in the Canadian legal system. Not only must both the provinces and federal government dedicate resources to ensuring that these programs are available across the country, but also that there's monies for additional training and resources for specifically offenses involving sexual violence. Funding must also extend to the ongoing needs of both survivors and offenders, from counseling and education for offenders to the implementation and expansion of independent legal advice for survivors. I will now invite Charlotte Hunter, a Two-Spirit advocate and member of the Avenues to Justice Report Advisory Committee, to the podium.
Thank you, Tamera. Anin, Tanshi, Ande Kugbi Anda Mat Indijnikas, Wisakote Equaindao, Kenokaming and Donchapa. I'm the former editor-in-chief of the Indigenous Law Journal and a member of the bar in Ontario. And as for many years, as my health allowed, I represented First Nation and Métis clients involved in domestic violence and family law litigation. There's a myth in Canada that Indigenous laws and legal systems either never existed or that they have been lost to 200 years of our shared colonial history. But in fact, it is the rights of Indigenous women, the dignity of our two spirits, and the respect for restorative systems of justice that have been lost. Systems of justice that are community-driven, survivor-focused, and maintain the balance necessary for sustainable communities. Our laws remain embedded in the language, in our oral traditions, and with community elders. Yet here we are in 2023, some of us living under legislation rooted in patriarchy called the Indian Act, others being handed cookie-cutter programs labeled as restorative justice, which are designed in Ottawa and assigned uniformly, that center more on reporting requirements than on the health of the parties involved. I've had the privilege of visiting and working with First Nation and Métis communities from east to west, and the voices in this report echo the same coming from Canada's far north. Our communities already have the tools we need to address domestic abuse and gendered violence. These systems can be rebuilt if our jurisdiction is acknowledged and community-driven justice initiatives are adequately funded. We need to be able to do things our way so that they can be done in a good way. Nui miigwech, merci. I'll now invite Audrey Huntley, co-founder of No More Silence, to the virtual podium.
Audrey, if you can just hold on one moment, we're not hearing you at the moment. If you can just unmute yourself, that'd be...
Sorry.
Okay, there you go.
Thank you, Charlotte. Thank you, Charlotte Miigwech, for those good words. Thank you, everyone, for your good words. Ani, Sego, good morning, everyone. I'm honored to have been invited to participate today. Sorry that I can only be here virtually. I had only a small role in this important work, which was to participate in an interview with Dr. Mandi Gray. Her invite was timely as I had been working on a chapter for a book, an anthology on the abolition of carceral institutions, police and prison. No More Silence, the community group of which I am one of the co-founders, has long embraced a non-carceral approach to our feminism and organizing against gender-based violence. This stems from our frustration with colonizer institutions and their failure to protect and serve Indigenous people, and our understanding that the pervasive violence against Indigenous women, girls, trans, and two-spirit people is inherent to the settler colonial project, which is Canada. We know that it will only end with meaningful decolonization. In our work supporting family and community members grieving a missing and murdered loved one, and supporting rape survivors, we have witnessed enormous harm come to those embroiled in the Canadian legal system, be they survivors or the families of those who were murdered or those who caused harm. Fortunately, as Charlotte, the speaker who preceded me, so eloquently outlined, Indigenous people have rich legal traditions and systems that we can draw on to develop alternatives. A core value in these is restitution, something that is completely lacking in the Canadian carceral legal process. Transformative and restorative justice processes have the potential to provide this aspect that I believe is crucial for all involved to heal. I began my work as an advocate in the Indigenous community over 25 years ago, and one of the first projects I was involved in was research looking at the use of RJ in cases of violence against women and children with the BC-based Aboriginal Women's Action Network. At the time, we had serious concerns as these so-called restorative justice initiatives were being led by a patriarchal leadership that hadn't even begun grappling with their own legacy of intergenerational abuse resulting from the residential school system. We have come a very long way in the past 2 decades, and we have learned so much. We know with certainty that the status quo doesn't work for anyone, and certainly not Indigenous people. We need to end the mass incarceration of Indigenous people and develop pathways for all survivors that have their and their communities and mainstream society's best interests at heart. Thank you. I will turn the floor back to Pam Hrick to close this press conference.
Thank you, Audrey, Charlotte, Dr. Burnett, and Dr. Gray for sharing your expertise and experience here with us today. I also want to acknowledge that the Avenues to Justice Project report was generously funded by the Canadian Bar Association's Law for the Future Fund and the Department of Justice Canada. Based on the recommendations in the report, LEAF is calling on federal, provincial, and territorial governments to take action to expand access to restorative and transformative justice for sexual violence. We need governments to work towards ending moratoriums on these forms of justice in sexual assault prosecutions. We need increased and committed funding for restorative and transformative justice, including fully community-based programs outside the criminal legal system. We need more funding to enhance independent legal advice programs for survivors and to create those programs where they don't already exist. We must support more options for addressing sexual violence in this country. We've seen what doesn't work, and we have an opportunity in front of us to transform our communities and the way we see and achieve justice. We would now be happy to answer any questions.
Okay, at the moment, there's no reporters in the room. We have one reporter on the line. Christine, if you'd like to ask a question, please raise your hand. Okay, yes, we do have a question from Christine. Go ahead.
Hi, it's Kristen Schmitz from Law 360 Canada. I haven't seen the report yet. Are you making any recommendations for amendments to the criminal code, or is this completely outside the criminal code?
So as of now, there are provisions, as I said, in the criminal code that allow for the use of restorative and transformative justice. However, they are not allowed to be used based on essentially Crown policy manuals. So the law in that aspect doesn't need to be changed. However, we do have some recommendations around the fact that when you're not involving the state, if you're not going through Section 717 of the Criminal Code, there needs to be some protections around what goes on in a restorative transformative process. And when we talk to various practitioners, they've been introducing, say, confidentiality clauses and trying to create their own structures for this. But as it stands, you cannot contract out of being able to bring a criminal case. So there is some ambiguity about the safety of being involved in these structures outside of the state processes. So that is an area that we've recommended needs more attention and reform.
What has what responses or feedback have you had from the defense bar and from Crowns about what you're proposing?
We've actually talked to both Defence Bar and Crown across Canada, and surprisingly, actually both were very receptive in many ways to this particular area. And we heard from many, both Crown and Defence, that this sort of use of alternative measures, even in a sort of non-official capacity, is already happening quite a lot across Canada. That as Crowns and Defence work together to try to find a way to resolve their problems, sometimes it is happening outside of the criminal field or criminal trial field anyway. So while there is still a lot of contention, particularly among sort of senior staff in Crown areas about whether or not this is a good way to go, there is a lot of pushback internally and also a lot of support from Defence Bar in general.
Can you provide an example at all of a scenario where what you're talking about would make a difference? Just something more concrete, illustrative?
One example was we talked to both the defense lawyer who was actually helping the survivor who had reported and a facilitator. And once the charges were dropped against the person who had been charged for the sexual assault, both the person who caused harm and the survivor were still looking for some sort of resolution. And so with his lawyer and the lawyer representing the survivor, they came together to find a facilitator who could facilitate a process that occurred outside of the criminal legal system to come to a mutually agreeable resolution, which involved, as Audrey was talking about, restitution, that the person who caused harm would support the survivor by paying for her therapy and to engage this facilitator throughout the process. Of course, I need to stress here that this was two parties that were particularly financially privileged, as they both were able to retain legal counsel and as well pay for a facilitator to facilitate this process, which is not available to a majority of survivors and people who cause harm, especially those facing intersecting forms of marginalization. So we would like to see examples like that more frequently, but there needs to be financial resources in order to make that happen, because most people cannot afford to pay these expenses out of pocket to engage in these really important healing processes that happen sometimes outside of the legal system.
Just to add to this, there's been two examples in Ontario recently of survivors who have managed to convince the Crown to take their cases to a restorative process. And if you look up Robin Parker and Marley Liss have both engaged in these sorts of things and have stated about how important it was for them to be able to find redress in this manner, and that it worked out far better for them than a criminal trial. So there are definitely examples happening even despite the moratoriums. So yes.
What do you need to see happen to politically to make this happen? Your approach happen?
So I think what we need to see is governments heeding the recommendations that are set out in the report, again, co-authored by Dr. Gray and Dr. Burnett. We need to see those investments that we've talked about in restorative and transformative justice processes and practices. We need to see those sorts of evaluations that Dr. Burnett was talking about on the use of admissions or conversations that happen in those restorative and transformative processes. We need that to happen in consultation with folks who are actually doing that work as well. And we need to see that critical reevaluation of moratoriums where they exist or where they create very limited circumstances in which restorative and transformative processes can be used as alternative measures within the criminal legal system as well.
Thank you.
Okay, if there's no further questions, and we'll conclude the press conference. Thank you very much.
Thank you.
Thank you.
Thanks, Audrey.
Thanks, everyone.
Recording stopped.